Good afternoon, everybody. My name is Cohen, with me, Dr. Lindsey Hogg, and welcome to the latest in our webinar series at Farrar's building. This one is entitled What's Coming Down the Track, the New CPR Intermediate Track and What It Means. Before we start, just a little bit about myself. I'm 1999 call. I specialise in personal injury, generally high-value cases, spinal, brain injury, catastrophic injury, cases of that nature, often cases with an element of dishonesty within it. Lindsey.
I specialise in road traffic, credit hire and personal injury, in particular focus on industrial disease and noise-induced hearing loss. Now,
we're just going to get started, and we're going to share our screen. There we are. And just a couple of points to make before we begin. The first point is that this webinar is being recorded. And what that means is that tomorrow you will all receive a copy of the webinar by email. So no need to write anything down, take notes or email in tomorrow. You'll receive, as I say, you'll receive a link to it in the morning. And secondly, also there is a Q&A bar. As you know, if you have any questions you'd like to put during the course of the webinar, if we have time at the end to answer any questions, then we're very happy to do that. So let's get started. We can scroll through these couple of slides very quickly indeed, but just long enough for you to read what they say. And let's get going. All right. So insofar as what we're going to be talking about today is concerned, we're looking at the new intermediate track introduced within the CPR. We'll start with a background to the intermediate track, how we got to where we are. And after that, we'll take a series of separate subheadings. So we've got the application, when the intermediate track will apply, how cases are allocated, what the transitional provisions are. Thereafter, there are new bands, complexity bands, both in the fast track and in the new intermediate track. And we'll be looking at what bands apply and when, the consequences for costs, how intermediate track cases are going to be case managed, and how courts are going to give directions that will govern how they are managed. And finally, the evolution, where we're going from here. But first of all, let's just remind ourselves what fixed costs are and how they differ to standard costs. Broadhurst and Tan, Master of the Rolls, Lord Dyson said this back in 2016. The starting point is that fixed costs and assessed costs are conceptually different. Fixed costs are awarded whether or not they were incurred and whether or not they represent reasonable or proportionate compensation for the effort actually expended. On the other hand, assessed costs reflect the work actually done. And that, of course, makes good sense. Now, what we're not going to do in the course of this talk is we're not going to go through what the new fixed costs themselves actually are, how much in terms of pounds, shillings and pence you will recover for each type of case. Those details are set out in tables 12 and 14 to the new part 45. And it's well worth taking a moment after this, acquaint yourselves with what those costs awards are likely to be. Suffice it to say that they're going to be a lot lower than standard assessed costs that they used to be, over £25,000. But we'll get to all that in a moment. So very briefly then, a background and how we got to the new intermediate track. Firstly, everybody remembers, if you're old enough, the Wolf Reforms of 99, there was the very first system of fixed costs for small claims only. And in addition to that, council's fees were fixed in the fast track back at that stage. So that was, what's that, 24 years ago or so now. It was sort of the very beginning, the creepings of fixed costs within the civil justice system. Then you have the Jackson Report 2010, the Review of Civil Litigation Costs, which introduced a fixed cost regime for most fast track PI cases that we are familiar with and which we still use and which will continue to apply. Those reforms were implemented in 2013. And Jackson 2, that's to say the Review of Civil Litigation Costs, that took place in 2017. There was Jackson's supplemental report, which took a long time to come through the system. There was an initial MOJ response in 2019, and then the government's official response in 2021. And finally, on the 1st of October of this year, Jackson 2 has been implemented in a new set of Civil Procedure Amendment number 2 rules, 2023. There's a new practice direction and an explanatory note within the rules as well. But it doesn't stop there, because already there has been a consultation issued by the Ministry of Justice relating to issues arising from the new regime. And in fact, that consultation opened up before the new rules came into play, so between July and September. So there's all sorts of changes and proposals still floating around with no certainty as to what they will be just yet. There's also a judicial review brought by APIL as to the nature and the impact of the new rules. So there is still plenty of opportunity and plenty of prospects for change, even though the new rules are set.
As to the purpose of the reforms, there are a number of quotes here. So, deliver access to justice at a proportionate cost, to modify the CPR with the aim of reducing actual costs so far as possible, to restrict recoverable costs to that which is proportionate, to control the recoverable costs in advance, and facilitate earlier resolution through allowing parties to make more informed choices throughout the litigation process. And that's set out at the start of the explanatory memorandum to the Civil Procedure Amendment number 2 rules 2023. As to their application and the extension of the fixed regime costs, in respect of the horizontal effect, it applies to fixed recoverable costs to all fast track cases up to £25,000. As to the vertical effect, it applies to all civil claims up to £100,000 unless excluded or not within the scope, and we will come on to that later in this webinar. It introduces complexity bands for cases on the fast and intermediate tracks, and again, we will deal with that today in the webinar. Amends Part 36 in novel ways, and there are new rules for noise-induced hearing loss claims. This webinar won't cover the rules in respect of that, but if anyone does have any queries, then my inbox is open in respect of noise cases. The application of transitional provisions for non-PI and housing cases, rules in relation to allocation, assignment to complexity bands, directions on fast and intermediate track and costs, apply to claims issued on or after the 1st of October 2023. So that's the non-PI and housing cases. In relation to the transitional provisions for PI cases, the rules apply to a claim which includes a claim for personal injury other than a disease claim, where the cause of action accrues on or after the 1st of October 2023. The rules in respect of disease claims, so rules apply to a claim which includes a disease claim where a letter of claim is sent to the defendant after the 1st of October 2023. The government estimated that between the summer of 2017 and 2018, 6,000 cases would have fallen within this extended scheme.
It's worth bearing in mind, of course, that where the cause of action doesn't happen until the 1st of October 2023, we're unlikely to see any arguments or any intermediate track cases being allocated for at least 12 months, one would have thought, and possibly slightly longer. But it's useful to know now what's coming down the line, and that's why we're looking at the subject that we are. Insofar as the fast track is concerned, no change to 26.95B1. That's to say the fast track is the normal track for any claim, which is a claim for monetary relief, the value of which is not more than £25,000. Insofar as non-monetary claims are concerned, I should say that the courts apply similar rules. That's to say 1 day maximum type claims where there's 1 expert per party and maximum of 2 fields. And it's in the interests of justice that a non-monetary claim should fall within the fast track. And as I've just said, the fast track is the normal track for claims only if the court considers that it's not going to last for more than a day, and the oral expert evidence is likely to be limited to 1 expert per party and in no more than 2 expert fields. no changes there. Now, here we get to the new rule, 26.97. When will the intermediate track apply? Well, the intermediate track will be the normal track where the claim is suitable neither for small claims nor for fast track. Not very helpful, doesn't tell us too much. The claim includes a claim for monetary relief, the value of which is not more than £100,000. And the court considers that if the case is managed proportionately, the trial won't last longer than 3 days, 2 experts per party, so far as oral expert evidence is concerned, and the claim can be justly and proportionately managed under the new Part 12, the new section of Part 28. But here's where we get interesting, and that there are no additional factors which would make the claim inappropriate for the intermediate track. So what are those factors? What additional factors might make the claim inappropriate for the intermediate track? Nobody knows. There's no guidance within the rules at all, within the explanatory memorandum, nothing to guide us as to when it won't be appropriate for a case worth between 25,000 and 100,000 to be allocated to the intermediate track. The other point is that the intermediate track is only suitable where there's a claim brought by one claimant against 2 defendants or 2 claimants against 1 defendant, where you end up with multiple parties, that's to say more than 3, then it won't be appropriate to allocate to this track. Where the relief sought includes a claim for non-monetary relief, then the claim shouldn't be allocated to the intermediate track unless it's in the interests of justice to do so. So again, there's this huge judicial discretion as to when to put claims into the intermediate track and when not to. And here's the big unknown, subject to subparagraph 10, which we'll come to in a moment. The court may allocate a claim to the intermediate track where it considers it to be in the interests of justice to do so. Now, when would it be in the interests of justice to do so? What about, for example, a claim worth under £25,000, but that's particularly complex or has a novel point of law? Or what about where a claim is particularly document heavy, or where you don't think your claim is going to get done in terms of trial within 3 days? Would it still be suitable for the intermediate track, or would it not? At the moment, we just don't know the answers to these questions. Or what about where there's a claim worth under 100,000, between 25 and 100, let's say £50,000, but it's a brain injury case, a mild brain injury, in which there are 4 or maybe 5 experts on each side. What will happen then? Will that be an intermediate track case, or will it not? There's real scope for argument here.
Now, looking at subparagraph 10, which Howard's just referred to, and the exclusions. So a claim must be allocated to the multi-track where that claim is a mesothelioma claim or asbestosis lung disease, one which includes a claim for clinical negligence, unless the claim is one which would normally be allocated to the intermediate track and both breach of duty and causation have been admitted, and also a claim for damages in relation to harm, abuse or neglect of, or by children or vulnerable adults. Again, this continues on. So a claim is one the court could order to be tried by jury if satisfied that there is an issue, a matter set out in section 66(3) of the County Courts Act 1984, or section 69(1) of the Senior Courts Act 1981, or a claim against the police, which includes a claim for an intentional or reckless tort or relief or remedy in relation to a breach of the Human Rights Act 1998. And the note that needs to be taken in respect of paragraph D above is that includes a claim for fraud. As to protected parties, although not explicitly excluded from the intermediate track within the CPR 26.9 subparagraph 10, also, as alluded to earlier, CPR 45.16, deals with the fast track claims, and then there's the intermediate track claims, and again a separate section to fast track noise induced hearing loss claims, and these do not apply where a party is a protected party. So the question that needs to be asked is, so protected parties appear to fall within the intermediate track and associated directions, but are not subject to the fixed costs of that track. There is a question, why is there a hybrid situation? It's unclear until the courts deal with that particular matter. As to allocation, there's no change to the rules in relation to this. It was previously CPR 26.8, it's now CPR 26.13. And again, the relevant factors include financial value of claim, nature of remedy, complexity of law evidence, number of parties, value of counterclaim or additional claim, amount of oral evidence, and views expressed by parties and circumstances of the parties.
Next, we come to a whole new issue introduced by the new CPR 26.14, and that's the issue of assignment. So where previously you had small claim, fast track, multi-track, and any claim in the small claims track was just a small claims track claim. Same fast track, just a fast track claim, and equally a multi-track claim, no matter where within those tracks any claim might fall. There's a change now insofar as in both the fast track and the intermediate track, there are 4 separate complexity bands within each of those tracks. So within fast track, there's complexity bands 1 to 4. And within intermediate track, again, there's complexity bands 1 to 4. And the costs rules in both the fast track and the intermediate track will vary, and the amount of costs you can recover, or for a defendant that you may have to pay, will vary according to which band the claim falls and in which track. So where previously, if you had a good memory, you might be able to remember what the fixed costs were in any given fast track claim or small claims track case. The fact is now with that number of bands in both the fast track and also the intermediate track, you're going to have to refer to these tables in part 45 because there are a vast number now of different costs awards or different fixed costs that will apply in different situations, depending on which stage the case gets up to when it's finally disposed of or concluded. It's worth bearing in mind that the assignment of cases doesn't apply to noise-induced hearing loss claims. That's under section 8 of part 45. An interesting feature of this part of the new rule is that the parties can agree which complexity bands a claim should be applied to or assigned to. That's important because depending, as I've said, on which band a claim is assigned to will determine what costs are applicable. But of course, the parties may not agree, and if they don't agree, then the court may ultimately direct that a different complexity band is appropriate, or equally, where the parties do agree on a particular complexity band, a court may still say that it disagrees and it actually opts for a different complexity band, having regard always, of course, to CPR 2613 and those factors which are relevant to the issue of allocation. One new thing parties will have to do, of course, is to state their proposed complexity band within their directions questionnaires, or if there is agreement, then the parties must state what that agreement is. Now, these are the complexity bands. As I've said, got these bands both in the fast track and in the intermediate track. And what's really interesting is that it appears that 2 separate people or groups of people seem to have drafted the rules separately because the issues one has to consider as to which is the appropriate band in the fast track are very different to the issues that one has to consider when one's considering assignment in the intermediate track. So in the fast track, for example, the most simple of non-PI RTA claims, defended debt claims, they'll fall within band 1. Of course, band 1 is the band in which the lowest costs will be recoverable out of the 4 bands. In band 2, one is looking at road traffic PI claims, which either started or should have been started under the RTA protocol, and PI claims brought under the package travel claims protocol. Band 3 are road traffic PI claims to which the protocol doesn't apply, so the more complicated claims involving contrib or fraud or any other type of issue of complexity. EL and PL, employers' liability and public liability personal injury claims, possession claims, and housing disrepair claims. And in band 4, which is the band in which the highest fixed costs will apply in fast track, then band 4 applies to employers' liability disease claims other than noise-induced hearing loss, complex possession or housing disrepair claims, property or building disputes, prof neg claims, and any other claim brought within the fast track, but which is complex. Now, again, this issue of complexity arises both in the fast track and in the intermediate track, and it's not really clear what constitutes a complex claim and what doesn't. But at least in these complexity bands in the fast track, one knows what one is looking for. So you know broadly what kind of case your case is, you know where it will fall. Is it, did it fall within the protocol, or should it have done? Is it an RTA case without PI? Is it with PI? And so you'll easily be able, should easily be able to slot your case into one of the appropriate bands, complexity bands within the fast track. But the same isn't true when you get to the intermediate track. And as I've said, that, remember, is for cases worth between £25,000 and £100,000 when one is dealing with monetary claims. So band 1 will apply to any claim where there's only one disputed issue and trial is expected to finish within 1 day. Now, that will include PI claims where liability or quantum is disputed, RTA-related non-PI claims, and defended debt claims. And you can already start, before I even get to bands 2 to 4, you can already start to see that there may be issues with this. So, for example, why should parties be entitled to recover only the lowest level of cost on band 1 claims in the intermediate track, just because there is only one disputed issue, where that disputed issue might be a very complicated accident reconstruction issue, or it may be a very complicated issue, a medical point going to quantum, which requires a number of experts and voluminous medical records, or other sorts of medical literature. But anyway, that's what the rules currently say. You don't look at the type of claim broadly, you're looking at the number of issues and what those issues are. Band 2 applies to any less complex claim. Again, one throws one's hands up at the question, well, what's a less complex claim? Less complex than what? And we don't know yet. So any less complex claim where there's more than one issue in dispute, and that will include PI accident claims where both liability and quantum are an issue. Band 3 will apply to any more complex claim when there's more than one issue in dispute, but which isn't suitable for band 2. And the suggestion is that may be noise-induced hearing loss claims or any other kind of employer's liability disease claims. But for now, these are very nebulous, very broad bands. It's very hard to know exactly in what cases they're likely to apply. Band 4 will apply, and again, very unhelpfully, will apply to any claim which would normally be allocated to the intermediate track, but which isn't suitable for bands 1 to 3. And that will include any PI claim where there are serious issues of fact or law. Now, again, what does that mean? If this means it will only apply in cases involving groundbreaking legal issues, then it's barely going to apply at all. And what's the serious issue of fact? How does one differentiate that from a lesser issue of fact? Where does fundamental dishonesty fit in? Which band, complexity band within the intermediate track will FD cases fit into? One also has to bear in mind that assignment takes place at the direction stage. And if the claimant solicitors have done an awful lot of pre-action work, only then for the defendant to make very late admissions within the defence, then in fact, according to what these bands say, the claimant solicitors will only be entitled to recover for very limited costs, even though they've done a very large amount of work.
There may be reassignment in relation to the complexity bands. So CPR 26.181 states a court may, on application or its own initiative, reallocate a claim to a different track or reassign a claim to a different complexity band. And it goes on at subparagraph 2 to state where a claim is allocated to the intermediate track and directions have been made, the court may only reallocate the claim where it decides that there are exceptional reasons to justify doing so. The court may only reassign a claim to a different complexity band where there has been a change in circumstances since the claim was initially assigned, and the court decides the change in circumstances justifies reassignment. In respect of the reassignment, it's not clear what would the change in circumstances need to be in order to justify reassignment. And again, it will be a matter of case law in order to consider what the court deems to be appropriate in the circumstances. In relation to the reassignment and the costs that would be applicable, CPR 45.14 deals with this, wherein any claim to which section 6 or section 7 of this part applies, the court reassigns a claim to a different complexity band. The costs which may be allowed are those applicable to the complexity band to which the claim is reassigned, as if the claim had been assigned to that band at the outset. And that again, the same applies to the reallocation to a track, and there's no power to order pre-reassignment or reallocation costs in the circumstances. So it could move both ways. It could move from, say, band 1 up to band 2, or it could move from band 2, say, down to band 1. Costs of applying to reallocate or reassign are treated as an interim application. So table 1 costs only plus the court fees applies. In this presentation, they're on the table set out with the costs, but they are easily accessible within the white book. So for fast track bands 1 to 3, it would be £250 plus the relevant court fee. For band 4 fast track, for in the intermediate track and for the noise induced hearing loss cases, it would be £333 again plus the court fee.
Now, dealing with costs, as we've said, we're not going to set out exactly what the costs are within this talk, but this is where you will find where the costs are. So in terms of the fast track cost, CPR 45.44, go to table 12. Table 12 sets out all the various costs. There are 4 columns going left to right, bands 1 to 4, and going downwards, there are the various points of the litigation up to which you can claim your cost. If the cost settles very early doors, you only get the first row. If it settles a bit later, up to trial and then trial itself. So it's there are, as I've said before, a lot of different variables and a lot of different potential costs, fixed costs that will apply depending on how big your case is and when it's disposed of or when it's concluded. Insofar as intermediate track is concerned, well, there you want to go to 45.50 and head towards table 14 to set out the costs, again in tabular format. The disbursements are set out in section 9. Now, in the intermediate track table, table 14, going down the table, there are various stages from 1 to 15. And these stages, again, set out different time points within your litigation, starting from pre-issue in stage 1 to an infant approval at stage 15. And again, you will recover the fixed costs on the table, depending going sideways, which band you're in, and going down the table, depending on at what point your claim either settles or concludes. Figures in stages 1, 3, 4, 5, 6, and 8 are cumulative totals. So, and I'll explain in the next couple of slides what those stages mean. But if, for example, your claim settles after witness statements are exchanged, then which I think that's either stage 5 or 6, whichever it is, then you'll get all of the costs cumulatively up to stage 6, depending on which band your case sits in. There are certain stages which involve additional specific sums only for certain steps if those steps are carried out. And those steps relate to specific legal advice, conferences, pleadings, and that sort of thing, where again, as I say, you'll only recover those costs if you've incurred those specific expenses. And there's a separate table and a separate rule for noise-induced hearing loss claims. I think I've addressed already what table 12 tells us. On the fast track. Table 13 relates to specialist or specific legal advice. You can only recover specialist legal advice in the fast track where the claim is on complexity band 4 and where either an advice or a statement of case is obtained from a specialist legal representative or a trial advocate, and it is justified to do so. And there are going to be questions as to when it gets to the end of a case, is it justified to go to counsel for specific matters, for pleadings in specific sorts of cases? Now, generally, if we're dealing with complexity band 4, the more complicated cases, you might think that going to counsel or any other specialist legal representative would be justified. But the argument there, no doubt, will be had at some stage. And what Table 13 allows for is a fixed cost of £1,000 for written advice or a conference and £500 for drafting a statement of case. And disbursements on fast-track cases are very similar to as they are now. So you'll be able to recover free medical records, medical reports, any, that should say, medical, non-medical expert reports under the pre-action protocol, phone hearing costs, any other disbursement reasonably incurred due to a particular feature of the dispute or any requirement of the rules, in addition to an expert's trial fees, translator or interpreter fees, and any witness expenses. And in effect, any disbursement which has been reasonably incurred other than a disbursement covering work for which costs are already allowed. Now, gets a bit more complicated, as I've said, when one hits the intermediate track costs. And here, as I've said, there are these various stages. Stage 1 will allow for costs, pre-issue costs, up to and including service of the defence. Stage 3 will take you from service of the defence to the state of the CMC or any order for directions, whichever comes earlier. And then it goes up. So from stage 4 goes from the end of stage 3 to inspection of documents. Stage 5, service of witness statements and expert reports. Stage 6 takes you from the end of stage 5 to the pre-trial review or to 14 days pre-trial. You'll remember I mentioned a moment ago that in certain cases, at certain stages, you'll only be able to recover costs for specific work that is specifically done. And you'll have to justify getting that work done. So at stage 2, once again, specialist legal representative who provides post-issue advice in writing or a con or a drafting of statements of case. In that case, you will be able to recover for that disbursement. Stage 7 is similar, except it applies after the defence is filed. So if there's been an advice, a written advice or a conference, then as long as that's done after the defence is filed, that will be recoverable as well. Query, can you have both? Can you have your costs at stage 2 and at stage 7? Presumably you can, but we don't know that yet. And at stages 13 to 15, there will be additional costs recoverable by solicitors for attendance at a mediation or a JSM. Stage 14 applies where a specialist legal representative attends at a mediation or a JSM, that would be counsel at a JSM. And stage 15 relates to attendance at an settlement approval. And again, another question which strikes one is whether one will be able to, claimants, for example, will be able to claim both its costs at stages 13 and 14. Will it be reasonable and justified to have both a solicitor attending a JSM and counsel attending JSM, as usually happens now? Will that still be justified in an intermediate track claim with a value of under £100,000? We just don't know. And CPR 4550 says that those specific costs will only be allowed where legal advice is obtained from or a statement of case is drafted by a specialist legal representative within their specialist expertise or the intended trial advocate, and the use of that person to advise or to draft is justified. Now, the court may take a very different view in a case worth £26,000, whether it's justified to obtain all of these written advices and have all of these conferences. And it may take a very different view from that to a case worth £95,000, where it might very much more likely be justified to obtain this additional legal advice. And so far as disbursements on the intermediate track are concerned, court may allow any disbursement which has been reasonably incurred other than one covering work for which costs are already allowed in the governing section.
As to the exceptions and the escapes in relation to costs, CPR 45.9 for exceptional circumstances. The court may consider a claim for an amount of costs, excluding disbursements, which is greater than the fixed recoverable costs referred to in section 6, section 7 or section 3 of this part, where there are exceptional circumstances making it appropriate to do so. Again, there's no explanation as to what exceptional circumstances are. As to unreasonable conduct, 45.13 deals with this, and it entitles the party successfully alleging it to a 50% uplift in costs or a 50% reduction. For unreasonable behaviour is conduct for which there is no reasonable explanation. And the point to take away from that is there will be satellite litigation in respect of the arguments around unreasonable conduct. Vulnerable party or witnesses are dealt with at CPR 45.10, and a claim can be made for a sum greater than the fixed costs if a party or witness is vulnerable. That vulnerability has required additional work to be done, and by reason of that additional work alone, the claim is for an amount that is at least 20% more than the amount of fixed recoverable costs. But how will this work in practice? And what needs to be taken away is the fact that that work will have already been incurred before the court determines whether in fact this CPR rule does in fact apply. So there will be cases where additional work has had to be incurred, additional costs have had to be incurred, but when it comes to the court assessing the costs, it may not fall within CPR 45.10. But 45.11 and 45.12 are important to note in respect of these fixed costs. So if the court assesses costs in a sum less than 20% above the fixed recoverable costs, the court may order the lesser of the fixed recoverable costs or the assessed costs, and these may be lower than the fixed recoverable costs. The claiming party may also be responsible to pay some or all of the costs of the detailed assessment and costs only proceedings. Moving on to part 36 and the impact that these reforms are going to have on it. 36.23 and 36.24 are the two relevant provisions. So a successful part 36 offer at trial will only entitle a claimant to a 35% uplift on the relevant costs, i.e. so that's the difference between the fixed costs for the applicable stage when the relevant period expires and the stage applicable at the date of judgment, in addition to the usual benefits of CPR 36.17. So Howard went through before the tables and how they're set out and the different stages. So again, it's the difference between the fixed cost for the applicable stage when the relevant period expires. So again, looking at that table, identifying that stage that the offer was made, and then the stage applicable at the date of judgment and the difference between the two. Broadhurst and Tan is now overruled by statute, and it will no longer be possible to claim indemnity costs on the fast track or intermediate track cases. It's likely to be much less generous to claimants in relation to Part 36, and it may well reduce impact of Part 36 offers. But again, that's a question that will need to be answered as time progresses. Moving on to the directions in relation to the intermediate track. 28.12, the court shall fix a case management conference and may fix a pre-trial review. The following provisions apply in respect of directions in the intermediate track. Oral expert evidence is limited to one witness per party, save where the oral evidence of a second expert for any party is reasonably required and is proportionate, and the trial time estimate must not exceed 3 days, and that's contained at 28.14 subparagraph 2. Continuing on with the directions on the intermediate track, the following provisions apply in respect of directions in the intermediate track, unless the court orders otherwise. But if it does, is the case being managed proportionately and efficiently, under CPR 28.14 that also needs to be considered when determining the directions. Rules 28.2 subparagraph 3 and 4 apply in respect of disclosure, so the usual standard disclosure. But these two subparagraphs are really important to note. So the total length of all the permitted witness statements and witness summaries of a party shall not exceed 30 pages, and any expert report shall not exceed 20 pages, excluding any necessary photographs, plans, and academic or technical articles attached to the report. And those two subparagraphs really need to be noted in respect of the length of the witness statements and the length of the expert reports. And in particular, in respect to the expert reports, that information will need to be relayed and clearly relayed to any expert that is instructed.
We're almost at the end. I would just say, just going back to that last slide, it's a really important point because about the length of the statements and the length of the medical reports, because what's the punishment? What's the sanction if a report goes over? What's the sanction if it goes a bit over or if it goes substantially over? What happens if you're dealing with a case worth, as I've said, £95,000 involving a detailed or an unusual either a bony, a brain, a spinal injury, in which there are voluminous medical records, all of which are wholly relevant to the experts' discussion on causation and prognosis. What happens in that case? Are we to say, well, the rules say 20 pages, so that's it and no more? Does one apply to reallocate to multi-track on the basis of complexity? It's very unclear, but if these rules are to mean anything, then presumably we're going to have to, all of us, try as hard as we can to comply and to remain within their restrictions, but it won't be easy. Now, finally, we just wanted to take a moment to have a think about what these rules, what these changes, what they may do to behaviour, both claimant behaviour, defendant behaviour, and also court and judicial behaviour, because there are going to be substantial changes, not imminently, but coming down the track in perhaps 12 or 18 months' time. Firstly, you can see why claimants would now wish to increase the number of claims that they're issuing in excess of £100,000. It's obvious the standard costs rules will still apply to multi-track claims and claims over 100,000, and those costs won't be limited. So there's a good reason for claimants to try and get their borderline cases over the £100,000 boundary as often as they can. Claimants may also seek to find special or complicating factors in an attempt to up-allocate cases, that's to say up-allocate them out of the intermediate track and into the multi-track. So even if in terms of value alone you can't get over the £100,000 barrier, it may be that with number of experts, complexity of issues, or something else, serious issue of law or fact. We'll remember that was the wording within the rules as to what's in a band 4 case. It might be that again will be sufficient to push a band 4 intermediate track case into the multi-track. And equally increasing use of counsel, where this can be justified from claimants' solicitors if they feel that would benefit them and their cases. Potential changes in defendant behaviour, challenges to allocation of track and challenges to banding. Of course, the more successful challenges a defendant can make, the more limited they can ensure that the claimant's costs can be. So it might be in appropriate cases, it might be that they think it's worthwhile to fight the allocation or to fight the banding. And equally, because the costs that are at play are now limited in cases up to £100,000, they may not be quite so keen to settle cases up to that value, where previously they might have wanted to put a bit more money on the table in order to prevent spending more money and spending more costs going forwards. And what might courts do? Well, it may be that courts are unwilling to down allocate fast track and intermediate track cases. The point being that one of the reasons for these rules is for certainty, so that everybody knows, as far as is possible, where what track their case will fit in and what band within what track their case will fit in. And the courts may start off by prioritizing the certainty and stability over anything else, in which case one might find that the courts are very prescriptive in drawing the 25,000 boundary and the 100,000 boundary and refusing to depart from them, save in the most exceptional circumstances. But having said that, you might think there's a good reason for the courts to push low-value, low-end multi-track cases back down into the intermediate track. Now, why would they be tempted to do that? Well, firstly, they wouldn't have to cost budget. They wouldn't be a CCMC anymore, but they wouldn't have to go to the time and effort of cost budgeting. And we know just how much the district judiciary don't enjoy, and not just the district judiciary, don't enjoy cost budgeting. So that would be one way to avoid doing it. And the other thing, of course, is that by pushing low-end multi-track cases back into the intermediate track, judges are able to limit trial length to 3 days, so they save time, and they can limit the number of experts, which would save cost as well. So it may be that we see some of that going forwards too. So do we think, now that we've taken a whistle-stop tour of the new intermediate track, do we think that the aims of fixed costs are going to be achieved? Will the new intermediate track reduce costs as far as possible? Well, there seems no doubt that the answer to that question is yes. As I've said, the tables set out in a prescriptive way what parties can recover on costs in all cases up to £100,000. But does the new track allow parties certainty and enable them to make informed decisions? Well, I think certainly in the early days, the answer to that question is definitely no, for all the reasons that Lindsey and I have set out, all the potential pitfalls and rabbit holes that some of these cases may fall into. In the early days, we just don't know where this is going to go and how it's going to operate. Will it facilitate access to justice? If that was one of the intended aims, seems unlikely to achieve it. And just finally, before we take a quick look at some of your questions, where do we go from here? Now, the consultation, the MOJ further consultation that I mentioned right at the start, looked at a total of 6 further potential areas for the extension of fixed costs. The first of those relates to cost assessment hearings, detailed assessment hearings, and it's envisaged that rather than have expensive and complicated and long-winded detailed assessment hearings on relatively low-value matters, that there should be a shortened detailed assessment type procedure, the costs of which should be limited to £500 on each side. And the idea is there'll be a points of dispute, a short response document, and then the matter will go straight to a hearing. But again, one can see how the the tentacles of fixed costs are expanding and extending to not just trials and trial work, but really all related civil type work. Secondly, the consultation discusses the potential for fixed costs in Part 8 and costs only proceedings. And the fixed costs envisaged are really very, very low indeed. £300 for a claimant, £150 for a defendant. So again, no one's going to do particularly well financially out of that. Inquest costs of any proceedings to restore companies to the company register. The idea is to extend fixed costs into those areas too. One area that the bar, certainly PIBA, has been heavily involved in lately is advocacy fees, where cases either settle late or, more likely, where courts vacate trials and other hearings late the night before the hearing is due to take place. And the proposal there is that counsel's fee should apply 100% if a matter settles on the day of trial, or 75% if it either settles or is vacated within 2 days of trial. Because of the nature, sadly, of the current state of the civil justice system and the court system and the way things are, trials and cases are so often vacated right at the last moment that it's becoming a real problem, particularly for junior members of the bar. Fifthly, there is a proposal to update trial advocacy fees in light of high inflation that we've seen over the last 2 or so years. No barrister is going to be particularly pleased to hear of the proposal, which is currently on the table, of a 4% uplift for cases within bands 1 to 3. No proposal of any uplift for band 4 cases, which is odd, given that they're likely to be the most complicated of the bands. And finally, clinical negligence claims. There is a plan to extend, once again, fixed costs into clin neg cases as well. And Lindsey, do we have any questions?
Yes, we do. Answering the first one, for PI claims which will not fit into the new cost regime for some time now, where can you find reference to the old cost rules which will be in place for some time? On the online version of the CPR, I'm not referring to the justice.gov website, but on Westlaw, it is set out at part 45 and part 45X, yes. I believe, Howard, and it does say from 1st of October 2023 and before 1st of October 2023, it is still contained on there for ease of reference, but I understand that they have taken it off the justice.gov website.
And particularly because these transitional provisions aren't going to kick in for a little while yet, practitioners are going to need to know what the existing rules are and what the new rules and what the new provisions are going to be too. So there'll be easy access to both sets of rules for a good long time to come yet, I'm sure. Is there another?
Yes.
It's just, I can't access it. Yes, I can. Let's have a look. Do we know when a new DQ form will come into force to cover the changes? Will the new DQ form only be applicable on PI claims where an accident date was post the 1st of October 2023? That's an excellent question. And my anticipation, I haven't seen one myself yet, but I anticipate that there will be a new DQ form already in circulation, which will allow for a box, and that box will ask the parties, is there agreement as to complexity band? If so, which complexity band do you say this case falls within? So in addition to which track do you say this that this will fall in, which band do the parties say that that this case falls within? Is there agreement? Is there not? If yes, what have the parties agreed? If not, what do you, claimant or defendant, what band do you say the case should be in? But I'm almost sure that there will be a new DQ in circulation either now or very, very soon.
Believe that one question may be follow on from the first question that we answered. What do you do if you don't have access to Westlaw? If that's in relation to the fixed costs that have been referred to, you obviously still have physical copies of the white book that can be referred to in the circumstances. And I'm not sure of this, but other online providers of the white book, again, may be able to have access to older versions in the circumstances.
Yeah, wherever you're getting wherever you've got your rules from up till now. And it may be if you don't have it on computerized in a computerized format, it may be worth photocopying part 45 and the existing tables and protocols, if that's what you need to do in order to have a reference going forwards. There's a question here. Lindsey mentioned exceptional circumstances at CPR 45.9. If this applies, is there any upper limit or guidance as to what costs are then limited to? That's, again, a very good question. I'm not aware that there is. I don't think there is. And it's a concern, certainly. It's a bit like the, unlike the unreasonable behaviour, where you're limited to either getting a 50% cost uplift or docking of 50% from your costs. If there are exceptional circumstances, one would assume, for current purposes, that you'd be entitled to recover your costs up to standard costs as you would get them before the 1st of October of this year. But unless, Lindsey, you can add to that, I don't think there's any guidance currently. There will be case law, no doubt, going forwards. This is the stuff that PI practitioners will get their teeth into for a good while yet, but I don't think there's any guidance currently.
There are 3 questions that fit quite neatly together. Where do you see credit hire only cases fitting into the banding band 1? Will credit hire be deemed complex or simple? And in credit hire matters over 25,000, which are likely to be allocated to the intermediate track where liability is admitted, do you believe that disputes surrounding the need for a credit hire vehicle, enforceability, impecuniosity, period, etc., will justify allocation to band 2 due to there being multiple disputes? I'm sure Howard would add to this, but credit hire, it's not clear as to what band it will fit into. Obviously, credit hire cases, is it a question of, is basic hire rate evidence in question? Is impecuniosity in question? Are there intervention letters? Are there other issues? It may be a matter of looking at each individual case as to what may be the appropriate banding, or again, how the court will determine whether that considers there to be multiple issues in respect of that particular case or not.
If we just going back to the complexity bands, just trying to remember where there we are. This is fast track, this is intermediate. So in terms of where credit hire is likely to fit, I suppose if liability is disputed, is admitted rather, and the only disputed issue is a credit hire matter, potentially might it fall into band 1, a non-contentious or non-complex credit hire case? Then yes, potentially it might do. Equally, might it fall within a less complex claim where there's more than one issue? There might be a low-level PI claim plus a credit hire claim or something else. I would hope it may fall into band 2. If credit hire of any type falls into band 1, you start to struggle to see what else would be band 2 and then what would be band 3, and you end up with band 4, which is for such complex or such rare cases as in effect to be pretty meaningless and not to be of any real assistance. So I would certainly argue that a basic credit hire case should probably fall into band 2. I would hope for that, but hard to know at this stage.
And again, even if it's a credit hire plus, say, a recovery and storage charge, again, if credit hire fell into band 1 only, but then an additional recovery and storage claim for, say, £180 was added on, would that really justify pushing it up to band 2 because more than one issue is in dispute? So I agree with you, Howard, that it would seem sensible to allocate them to band 2.
Yeah. Okay, well, it's 5:30 and we did promise ourselves and we wouldn't go on for more than an hour. Thank you very much indeed for joining. We hope that that's been helpful to you. And as I said right at the start, Farrars will email you tomorrow morning with a link to this webinar, so you'll be able to watch it back if you're a glutton for punishment and you want to see it again, but you'll have the slides and I hope that will help you. And if there's anything more Lindsey, myself, or anyone at Farrars can do, then we'd be delighted to help you. But thank you for joining. Thank you.
Thank you.